Hello, good evening, everyone. I want to sincerely appreciate you for yet another time to have a meeting together. It's the meeting that we have been doing since the beginning of this month, and we are looking on alternative dispute resolution for those of you that have been joining. And this training is brought to you by the Institute of Global Peace and Conflict Management, and the training is 100% free training from training to certification is a free training, and many people have been benefiting from this. We started on peace education, we did emotional intelligence, and now we are doing alternative dispute resolution. Next month, we'll be looking at peace and sustainable development, which is also some of the things that we need in our environment today. So I sincerely appreciate all of you for taking time to be part of today's training as well. And we have been looking at arbitration, and today we are in unit 4. We are looking at unit 4 on module 3, and I'm sure that we're going to finish with this module today. So by tomorrow, I will arrange the module so that I will send it out so that people can start going through it. So that you have the manual to begin to start looking into it, so that you prepare yourself ahead of time. For those of you that have been so consistent. So I really appreciate all of you for taking your time to join us. Ambassador Odipo, now you are an ambassador. Before you were a doctor, now you are Ambassador Dr. Odipo. And then we also have Ambassador Halima. Also, those were the people that were inducted last Saturday. I really appreciate all of you for taking time to be part of today's training as well. And we also have Ambassador Lottie here, also an inducted member, has been an inducted for a while now. And I really appreciate all of you for taking time to be part of it. In fact, what I'm so impressed about is your commitment. And I also talk about Ambassador Obi. All right, she's anticipating to be inducted in Inugu very soon. So I really appreciate all of you, and thank you very much for taking time to be part of today's training. Mr. Tengwa, I was expecting you to be at Abuja induction, but unfortunately, we didn't see you. But we hope that by November you'll be inducted anyway. That is it. So thank you very much for taking time to join today's training as well. We are learning together. I'm learning from you as well as you are also learning from me. Today, I want us to try as much as possible to finish on time. Maybe I'll just do at most 1 hour and then we are done with today's training. But today we are going to look at international arbitration. I've been talking about arbitration generally, and we'll also talk about international institutions that have developed some standardized rules for engagement. But today I want us to look at the international arbitration, how it operates at the international level. Do you understand? How can you arbitrate at the international level? How do you go about addressing issues that has to do with cross borders and transactions, international business engagement or relationship that has to do with cross borders? How do you go about addressing the issues? You understand? So we are going to look at that today, and I hope that you will have a great time as we continue today's training. But like we said before, if you join, do way to share it to someone, invite someone to also be part of the training, all right? And then you also comment by paraphrasing what you are hearing me saying. So it is a mark of attentive listening. So, and then also likes and all of that, it will help. Thank you very much. So we are going straight into the conversation. Let's look at what we have for today. We are looking at international arbitration, all right? And when we're talking about international arbitration, what are we trying to say here? International arbitration, we say that it is a widely used method for resolving disputes that arise in a global context. That is, it is not just a domestic or internal matter, but it's something that has to do with external affairs. Do you understand? That is cut across other geographical locations. Do you understand? It's not just about or within the country, but also across other national boundaries. That's what we're talking about. That's international arbitration. So it provides parties from different jurisdictions a neutral ground for adjudication, facilitating international trade and investment. Facilitating international trade and investment. So it's it's a kind of arbitration that takes place at the international level, and it provides an institution or institutions that considered to be neutral. You understand? They have no interest whatsoever in the matter, because it may be a matter between Nigeria and a company in another country, or it may be country level, a bilateral relationship. Do you understand? Nigeria, let's say Nigeria versus China. Do you understand? So all of these are international affairs. Do you understand? So you can arbitrate at the international level. Do you understand? So it gives the parties from different jurisdictions a neutral ground for adjudication, facilitation, international trade and investment. So that is international arbitration. So, but let's look at some aspect of international arbitration. All right, let's look at some aspect of international arbitration. First and foremost, we are looking at the definition and the purpose of international arbitration. The definition and what the purpose of international arbitration. All right, so international arbitration refers to a process where parties to a dispute agree to submit their disagreement to arbitrators instead of going through national courts. Do you understand? Now, it's possible that the case or the problem, the disagreement may occur in Nigeria here, but you may decide to submit this matter at the international arbitration ground. Do you understand? Because maybe in the process of signing the contract, you cited some provisions of arbitrations that in case of disagreement, you will use ICC or you use central rules to arbitrate or to navigate the challenges. Do you understand? So once the matter occur, whether it occur in Nigeria or anywhere, you can decide to, institute or initiate an arbitration process at the international community. So that's what it means. So the primary goal or the primary purpose of this is to achieve a fair resolution, maintain confidentiality, and expedite the decision-making process. Do you understand? So that is the sole aim of going into arbitration. What is it? You want to fast-track the decision-making process. Do you understand? You want to maintain confidentiality, and you want to make sure that whatever resolution you are making is a fair resolution. Do you understand? It's a fair resolution. All right? So that everybody will consider it to be a fair arrangement. Do you understand? Nobody feels bad about it. Do you understand? So that's what it is. So that's the purpose of going for arbitration. So another aspect of international arbitration is the legal framework. The legal framework. Let's say arbitration agreements, right? So there can be arbitration clauses, all right? For instance, typically included in contracts. So when you are signing a contract, you put in some aspect of arbitration that, well, should in case we have disagreement, this is how we're going to address the matter. So specifying that dispute may be resolved through arbitration. You are saying that for you and this organization, if we have any disagreement in the course of doing our transaction or interacting, as business institutions, if we have any form of disagreement, what we are looking at is that we're not going to go to court, we are going to arbitration. Do you understand? We're going into arbitration to resolve our differences. Somebody sent, one of our ambassadors sent me a publication today, and I was going through it. You understand, where the institution concerned is taking Nigerian government into international arbitration. You understand? Because they feel that the contract that was signed, or the contract that was given to them, was terminated unjustly. Do you understand? So they feel that it was not done right. So they are going into and if you can look at it, this is how Nigerian government has been wasting money. This one, recent, so many issues. They'll just woke up and then terminate the contract. And some of these things are outlined inside. But so far as their interest is fulfilled, it doesn't care how much Nigeria is going to spend to pay those people. Do you understand? And so these are the issue. So, but the people put all of those clauses when the contract was being signed, and now they say they are going to go into international arbitration to make sure that they get justice for fairly termination of their contract. So, and then submission of agreements. So, an agreement entered into after a dispute arises, committing to arbitration. So, but before you go, there must be an agreement. So, they also are trying to reach out to the Ministry of Justice through the Minister for Justice. Do you understand? So they are trying to agree with them, and they also let them know that we are going for arbitration. Do you understand? Since you cannot resolve the issue, or since you cannot restore our contract, if that is, they are saying that if you cannot restore the contract to us, we are going into international arbitration to see how we can seek redress in the matter. So then we have what we call the governing laws. All right, this is also another aspect of international arbitration. I talk about definition and purpose. I talk about the legal framework. I'm talking about the governing laws. All right, that governs the international arbitration. We have the national laws. You can have the ones that are domestically outlined. Do you understand? You can still use them. So the arbitration may be governed by the national laws of the seat, that is the legal jurisdiction where arbitration takes place. Do you understand? Or it can be in international treaties such as the New York Conventions. Then you can have international treaties where standardized rules have been outlined so that you can follow in case of any issues. Do you understand? So some of these treaties, like the New York Convention, which was done in 1958, facilitate the recognition and the enforcement of what? Foreign arbitral awards. So that's what this particular convention is all about. Do you understand? The New York Convention. Its the main focus is to recognize and make sure that the international arbitral awards are being enforced. Do you understand? That's what this convention is all about. So then we have also the Central Model Law, which was established in 1985. It provides a framework for arbitration procedures and is adopted by many countries because it's done by the United Nations Commissions on International Trade. Do you understand? So it's been adopted by most countries, because most countries that are members of the United Nations adopt this particular procedure. Do you understand? And then it applies across all of the member states that are members of the United Nations. Do you understand? So that is another aspect of the international arbitration. We talk about the definition, the purpose. We talk about the legal framework. We also talk about the governing laws. We are looking at the institutions and the ad hoc arbitrations. Ad hoc arbitration. We are looking at institutional versus what? Ad hoc arbitration. So institutional arbitration managed by established institutions such as ICC, LC, AAA. Do you understand? All of those are the institutions that we know that have certain procedure or standardized rules that you can follow when you want to go into arbitration. Do you understand? Or when you want to select arbitrators, you can use those standardized procedures that have been established by this institution. That's what we're talking about here. So we'll talk about an ad hoc arbitration. These are situations whereby the parties themselves decide to, appoint arbitrators on their own terms. Do you understand? They don't necessarily follow the standardized rules, but they can, select the arbitrators independently on how they want it, or depending on how and the people they feel that can be able to arbitrate on their behalf. So they do it without following any standardized rules. Such arrangement, we call it ad hoc arbitration. Do you understand? It was conducted independently by the parties without institutional rules. Do you understand? So requiring them to agree on procedure. So that is it. So they are not following any particular procedure. They just go on their own, do it. We call it ad hoc, right, arbitration. So then we also have arbitration process. We have been talking about arbitration process. We say that first of it is initiation, right? When you feel that there's a need for you to go for arbitration, then you take a step. And what do? You initiate the process. Do you understand? So the process begins when one party sends a notice of arbitration to the other party, detailing the nature of the dispute and the relief sought. Do you understand? So this is it. So once you feel that there's an issue and this issue cannot be resolved based on your communication with the party involved, you cannot decide to seek for arbitration. And the first thing you need to do is you initiate a process. You initiate what the process. Once you initiate a process, you communicate what the dispute is all about and what you are demanding for. Do you understand? Whether you are seeking for a restoration of a particular contract, like the people we are talking about here, they are saying either the federal government restore the contract or they will claim certain damages. Do you understand? That's what they're talking about. And then selection of arbitrators. Selection of what arbitrators? Parties typically select one or more arbitrators with relevant expertise. The selection processes can vary based on the arbitration rules or agreements. So if I use an ad hoc arbitration, you know that there's no particular rules governing it. But if you want to use an institutional rules, right? Then maybe you are using ICC or you're using your central, or you're using any of the ones that we mentioned yesterday. Some of them may be regional, like we talk about the East African arbitration, So all of those things are there. So you decide which one that you want to use. All right. So we talk about the preliminary meetings. That is the preliminary conference that we talked about yesterday. So a preliminary conference may be held to, set a timetable to also clarify procedural rules and discuss any other preliminary issues that needs to be addressed. Because you need to communicate the terms of engagement, the rules, the guidelines, the timelines, all of that must be discussed. Do you understand? So that's why you need to have a preliminary meetings. For instance, now, take for instance that maybe before this training starts, we can decide to have a meeting, all right? Okay, it's as we're going to this training, this and this and this expected. I think we did something like that. We communicated with you and explained to you that this is what and what we expect you to do in the course of this training, which most of you are doing. And then some maybe feel maybe our condition was so stringent, some of them are not even active. So that's it. But it's good that we should have that preliminary arrangement so we know where we are going and the direction we are flowing. Do you understand? So even if on YouTube, you join us through YouTube, you can comment. You can even share. on Facebook, we can also share. You understand? So that's what it means. So let's look at the hearing. So another aspect of international arbitration is the hearing. You understand? Okay, we'll talk about the hearing. Okay, so all of these are under the arbitration process, rather. So hearing. So presentation of evidence, all right? For presentation of evidence, here parties tender evidence available, whether documents or any form of evidence that you think is tangible enough to be provided, you present them. And then we'll talk about cross-examination, all right? Cross-examination. So in this situation, parties also take steps to examine and cross-examine the evidence provided by the parties involved. So this is so deliberation and award. So after the evidence have been provided and everything, then you deliberate and award is being pronounced. Do you understand? So we also look at some of the advantages of international arbitration, which are similar with all other advantages we have been looking at. We talk about neutrality, we talk about flexibility, we talk about expertise, we talk about confidentiality, we talk about efficiency. All of these are the advantages of arbitration or even alternative dispute resolution generally that we have been discussing. Do you understand? These are the benefits and these are the advantages that you enjoy when you approach the international arbitration. So, but let's look at some of the challenges, right, which are limitations that the international arbitration may likely face. We talk about cost, which has been what we have been discussing. We also talk about limited grounds for appeal. We told you earlier that in arbitration, there are limited chances for you to appeal the awards. Do you understand? Once a pronouncement is made, it becomes so limited for you to be able to amend, to appeal for any form of amendment. Do you understand? There are little chances of doing that. Then we'll talk about enforcement issues. Now, another limitation, another challenge of international arbitration is enforcement issues. Do you understand? So that is why sometimes you see, like maybe if sometimes country level, sometimes, or maybe a company in a particular country may decide to speak with the government of that company, and then if you do any business there, they will seize it, and then we force you to comply. Do you understand? That's why Nigerian private jets, presidential jet were seized because it was, then the property in Liverpool was also seized. The idea was just to make sure that Nigerian government comply. Do you understand? So, but there are enforcement issues. Do you understand? Jurisdictional variability is one of the things. So, enforcement of arbitral awards can vary significantly across different jurisdictions. Some countries may have less favorable attitudes towards arbitration, leading to difficulties in enforcement because some countries may not, they are not used to it. Like in case of Nigeria, for instance, now, because we're not used to arbitration. Do you understand? So even legal court cases, implementation of court cases, and the enforcement of court cases has not always been easy. I was at the Brekete family some other times who wanted to see the ordinary president. See many people coming around with court cases. Do you understand? Court cases, coming with court cases. Why are they coming with court cases? You get your judgment, go and implement it, but no way. They have to take it to the family to help them to enforce it. Do you understand? So these are some of the challenges. So if we are talking about court cases being so difficult to enforce in this country, then how easy is it going to be for arbitration? How easy is it going to be for arbitration? So you can see how it is. So sometimes some countries may not be, some such kind of things may not be, they may not tolerate such, they may not have a system that favors such awards. Do you understand? And then it becomes so difficult to implement it. So public policy defenses, all right? Respondents may challenge the enforcement of an award on public policy grounds, which can lead to unpredictable outcomes. But public policies may also have limitations whereby the contract has been signed before the policy. came into existence. I think we gave you one instances of a company between one company, that's GB or VG Group Energy, all right, versus Argentina yesterday, right? We gave you that example. Yeah, we say that the company, after investing, the Argentine government decided to introduce a regulation that affected their investment. And so they took it up, and then award was given in favor of them because they considered that Argentine government, went against the international treaties that covered their investment. So that's what it means. So even public policies can also can affect, in case the policy was on ground before this contract was signed. That's why you must do what we call due diligence. When you're going into a contract, make sure you do what a due diligence to make sure that at the end of the day, you will not be frustrated. It's not going to affect you. Do you understand? It's not going to affect you. So that's what it means. That's what it means. Yeah, let's look at other challenges that may face the enforcement of this, the enforcement of award. Talk about complexity of multi-jurisdictional disputes. Do you understand? So legal systems, diverse arbitration practices can all affect, the implementation. Do you understand? And so we talk about limited discovery and evidence gathering. Some of the challenges that may also confront the international arbitration. All right, limited discovery, that is evidence. For you to tender evidences may not be as easy as it is. Do you understand? So it may be also challenging for you to gather evidences. Do you understand? Discover evidence may be limited. So witness availability, bring witnesses to also come and testify, may also be another challenge, because sometimes you have to move them to a particular location for such kind of thing to happen, except whereby an online arbitration procedure is being considered, or conferencing is being considered, that it can be made so easy. So potential for delay, procedural delays. Why arbitration is generally quicker than litigation, delays can still occur, especially if parties engage in prolonged procedural disputes, or if arbitrators take time to issue an award. Do you understand? So these are potential challenges that you may see. Although we say that they are fast, but in situations whereby arbitrators themselves are delaying the process, or the type of dispute itself is so complex, it may take a little time for awards to be pronounced. Do you understand? So another thing is post-award challenges. If a party challenges the award in court on procedural grounds, this can extend the timeline significantly, because it may affect the time expected that this process would have been completed. Do you understand? So, but now you are taking it to the court will start its own process, and the court matter. So it now affects the whole system entirely. Do you understand? So arbitrator challenges. Some of the arbitrator challenges will have bias and independence. Concerns about the impartiality of arbitrators can arise. Do you understand? Particularly if one party feels that an arbitrator has a conflict of interest or bias. So once this is being defined, it becomes a problem, because for the arbitrator to proceed, once one party begins to suspect that you have some form of conflict of interest, or it discovers in the process that you have some form of conflict of interest, then it becomes so difficult to progress. And that's why the biasness of arbitrators sometimes comes in. Quality of arbitrators. The quality and expertise of arbitrators can vary widely. Less experienced arbitrators may struggle with complex legal issues. Struggle, do you understand? Those of them that are not way experienced. Maybe you go and hire someone that is not way vast and way experienced in their own field. It becomes so challenging. Most especially those that doesn't even have the background or doesn't have a legal background. It also becomes so challenging. So, but if you can have quality arbitrators that are way vast, even in legal and the other uh, and disciplines, then it's going to help fast track the process. Talk about cultural differences can also be one of the challenges. Cultural work differences, diverse legal cultures, right? Parties from different legal backgrounds may have differing perspectives or expectations regarding the arbitration process, leading to misunderstanding. All right, because where I'm coming from, this is how things works, and where you're coming from, this is how it works, and so it becomes so challenging, and then misunderstanding the setting as well. You understand? So negotiation styles can also be a problem based on cultural issues. Do you understand? Different cultural approaches to negotiation and dispute resolution can affect the dynamics of the arbitration process because we have we attach values on things differently. Do you understand? Something that may be so important to you, for me, it may not be something important. These are cultural backgrounds, these are belief issues. Do you understand? And they affect the process entirely. Do you understand? We'll talk about limited procedural rules. Limited procedural rules is one of the challenges facing international arbitration. Lack of uniformity, lack of what uniformity, because we have different standardized rules. You understand? ICC, essential, and many other regional procedures. So all of these are not uniform. All of them come up with ideas. They may have similarities, but they're not uniformly done. You understand? So arbitral discretion. That is, arbitrators have significant discretion in many aspects of the procedure, which can lead to unpredictability, which can lead towards unpredictability because anything can happen. All right. Because many of the arbitrators take decision as they feel like, okay, they may feel like, okay, it's okay, because they have the power to take the decision. And so once they take decisions, if you, and we also say again that in arbitration there are limited chances of appealing. So sometimes it becomes so challenging. It becomes a problem. You understand? Because you cannot predict how things turn out. Regulatory challenges also is also one of the things that are facing international arbitration. Compliance with local laws. Parties may face challenges in ensuring that the arbitration process complies with local laws, especially in jurisdictions with strict regulations, because it has to comply. Because when it comes to enforcement, you may have challenge if it's not complying with the local laws. Do you understand? That's why whatever award that is being awarded must have some basis upon which it can be enforced at the domestic level. Do you understand? You must have those bases. So we talk about changes in law. Shift in political or legal landscapes can impact the enforceability of arbitration agreement and awards. So such changes may occur and largely may affect the implementation of any award whatsoever. They will talk about the cost concerns. High initial costs, potential for overruns are all part of the challenges. Then awareness and understanding. Limited awareness can also be a problem. Small businesses or parties without legal expertise may not fully understand the arbitration process, right? So there are some businesses that don't even know that there's anything like arbitration for them to deploy and use and resolve disputes. Do you understand? They just feel like if there is any issue, they can go to court. They don't know that, okay, they can go into any business transaction using arbitration. You understand? So that's why it is. Many small organizations don't have this idea. So these are some of the challenges that international arbitration may likely face. Do you understand? When we look at the purpose, we look at the governing laws, we look at the administration process, we look at the enforcement and the challenges confronting arbitration, international arbitration. Let's look at the role of international institutions in arbitration. The roles of international institutions in arbitration. All right. If you have just joined us, you are just joining us, please do way to share the meeting with someone, invite someone to be part of the meeting. You may be doing so by promoting peace indirectly. They'll come and learn this peace and then trigger it down, all right, trickle it down rather into the society, and it will help to promote peace and good peace and make our society very peaceful. So let's look at international institutions that play vital roles to make sure that we have standardized rules to operate. What we're saying is that international institutions play a crucial role in the field of arbitration by providing a structured framework, resources, and support for resolving disputes. They provide a structure, a framework, a structural framework, resources, that is human resource, do you understand? And maybe some logistical resource, and then support for resolving conflicts. Do you understand? They are there always to support the process. So their functions enhance the efficiency, effectiveness, and credibility of the arbitration process. So let's look at some of the functions, some of the role they play. One of the roles that this international institution play is, maybe if I ask you, what are those international institutions we're talking about here now? I hope you can be able to mention. One is what? ICC, right? Then LCIA, that is London Court of International Arbitration. Do you understand? They are also there. And then we have so many of them, AA, and the other ones that we were talking about yesterday. Do you understand? Rasika in Kenya that we were talking about yesterday. All of them are institutions that we're talking about here. So one of the roles they play is rule development. They develop rules, right? That is standardized rules are being developed by this institution for us to use, right? So institutions like the International Chamber of Commerce, London Court of International Arbitration, and the American Arbitration Associations develop comprehensive arbitration rules that govern proceedings. Do you understand? These rules provide clarity on procedures, timelines, and responsibility of parties and arbitrators. So this is what these institutions are helped to achieve. Develop what rules. Develop what rules. Then another thing they also do is that they update the rules. That is when the rules leave a purpose, they update it. Or if there are new development, technological changes and advancement, they may decide to update their rules. Do you understand? To accommodate the current and future trends of things. Do you understand? The administration of arbitrations. They also ensure that cases are being administered and adjudicated. Do you understand? So case management is one of the things that they do. Institutions provide administrative support throughout the arbitration process, including managing the document, scheduling hearings, and facilitating communication between parties and arbitrators. That's what they do. So they are so vital in the process. They contribute a lot to make sure that there's this smoothness in the arbitration process. They facilitate the smoothness of the process. The appointment of arbitrators. Appointment of what? Arbitrators. Many institutions maintain list of what? Qualified arbitrators and assist parties in selecting arbitrators with the appropriate expertise and impartiality. So that's what they do. Appointment of arbitrators. They contribute. They help you to appoint those people that can help you in arbitrating your matter. Do you understand? That's what we're talking about. They have a list of arbitrators available, those that are qualified, and they're different. They have their resumes, they have their CVs, they know their exploits. Do you understand? So when you come with a matter, this institution will help you, they will guide you and help you to select arbitrators that will help you to, resolve your matter. Do you understand? So that's what so that you not just go and gamble and pick anybody and then you suffer the consequences at the end of the day. So providing neutrality. One of the roles that this institution also play is neutrality. They provide neutrality. Do you understand? Impartial forums. That is, by acting as a neutral party, institution help mitigate concerns about bias, particularly in disputes involving parties from different jurisdictions, from different countries. Do you understand? This neutrality is essential for fostering trust in the arbitration process. So they come in and then they stand on the side of nobody. They are not for anybody. They are just for the purpose of making sure that that matter is resolved the way it's supposed to be resolved. Do you understand? That is their interest. They'll talk about facilitating communication. They also facilitate communication between and among parties and arbitrators. Do you understand? They communicate and they define communication channels in which they can communicate, either through the letters or whatever notification they think they can give you, messages or whatever. So language and translation services. All right, some of these institutions have experts that are vast in different languages. They are linguists. Do you understand? And then they can speak so many languages. Some are vast in French, German, Portuguese, Spanish, Hausa, and all of that, Arabs, and all of that. Do you understand? So they can speak all of these languages. So they have them available there. So language cannot be a barrier. Do you understand? Language cannot be a barrier because someone is there to interpret. Even if Chinese, even if it is Japanese, whatever that you want to speak, people are there that have the skills and they are there to translate on behalf of you. So there's no challenge. Language can never be the barrier. This institution have such resource persons available for your services. So another role they play is to ensure compliance with standards. Do you understand? Quality control. Institutions often impose standards of conduct on arbitrators, ensuring that they adhere to principles of impartiality and professionalism. So there are standards raised by this institution so that if you are an arbitrator, you must maintain those standards. You cannot go below it. If you go below it, it means that when another case comes, they may blacklist you. You understand? They may take you out of the list of the arbitrators because you have undergone below the standards being raised by the institution. So they'll blacklist you. You understand? So when someone is looking for an arbitrator, they will not recommend you. So this is the role they play, ensuring compliance with what standards, monitoring proceedings. They also monitor proceedings. Institutions may oversee proceedings to ensure compliance with established rules and standards, providing an additional layer of oversight. So that's what they do. Training and education. Training programs are being organized by these institutions to provide knowledge, right? And then to arbitrators, counsel, and also then the parties are being trained So addressing best practices and development in international arbitration. So what are they training them on? Training them and inculcating them the best practices at the international level. Do you understand? So that you will not just come and do whatever you want to do. So publication and research. Institutions frequently publish reports, guidelines, and research on arbitration trends, contributing to knowledge base of practitioners and users. So if you want to, be a practitioner or a practitioner arbitrator, what you do, you begin to follow them now. You begin to follow some of these institutions. If you pick ICC or you pick AAA, you begin to follow them so that you continue to have an update of what they are saying concerning the guidelines, the new things that are happening, the future trends or the trends that are happening in the field. Do you understand? Promotion of arbitration. The institution also promote arbitration because they can conduct what we call advocacy, right? Like we were talking about here, you say that we can conduct advocacy, visit the Nigerian police authorities, visit the Ministry of Justice to make sure that arbitration units of this, where they don't have, are being established, and where they have, they are being strengthened, and where they have but they are not working at all can be activated to work. You understand? So we say we can do that. So after the training, so those of you that are committed to arbitration, we see how we can put effort together and begin to write to this institution or approach them and see how arbitration can be strengthened in our country. All right. Networking opportunities. They provide platforms for networking among legal professionals, arbitrators, and businesses. Do you understand? So, and this promote what collaboration and knowledge exchange. So that's what this helps. So, dispute resolution services. This institution also help in mediating and conciliating in matters. Do you understand? Many institutions also offer mediation and conciliation services as alternatives or complements to arbitration. So providing parties with additional options for resolving disputes amicably. So this is the role these institutions are playing. So they don't just leave you there stranded. They guide you, support you, provide resource persons. All you can do is just to pay them service fee and then administrative fee, whatever we call, and then pay the arbitrator fees. Do you understand? And then you have your issues being resolved. Talk about emergency arbitration. Some institutions have provisions for emergency arbitration, allowing parties to seek urgent interim measures before the full arbitration can commence. So that is what it means. Addressing contemporary issues, because technology has advanced, do you understand? And these are contemporary issues. So how do you integrate technology into the process? And that's what we're talking about, online arbitration. Do you understand? So all of this electronic document sharing, do you understand? Electronic signature signing, all of this can be done. Do you understand? And these are contemporary issues. Diversity and inclusion initiatives. Institutions are promoting diversity in arbitrators' appointment. Okay, appoint diverse arbitrators from India, from China, from Nigeria, from Malawi, all of that. They are come to represent. All right. Then sustainability practice. Some institutions are advocating for sustainable practices in arbitration proceedings, encouraging parties to consider environmental impact and adopt greener we must embark on processes that are environmentally friendly. Do you understand? Instead of driving to a certain location, just stay in your place so that we can reduce the emission of the greenhouse gases. Do you understand? So it's very important. So instead of traveling to far distance, you reduce such and then emit some of these dangerous chemicals in the air. You can stay in your place, connect, and we connect. Do you understand? And then we have arbitration. So advisory role, they also play advisory role, okay, guidance on best practices. Institutions provide guidance on best practices in arbitration, helping parties navigate complex issues and avoid common pitfalls or common errors. Do you understand? So that's what it means. They guide you through, they see you through, right? They provide necessary advice